And good evening, ladies and gentlemen. Welcome. Mark Emery here with NATF, Lighthouse Law Club, and most of all, Americans for Freedom is what we're all after here, at least in one regard or another. Big goings on in the world, as you well know. Tonight we're going to cover common law in action. In fact, we're going to see basically how we convert the state court into common law. It's currently being done in the Princess Patriot case, the Interchange Bistro in Minnesota. And so we'll use that as an example. But just to set the stage, we're going through a great awakening. We're on the verge of some major shifts in the world and how things are done. And I just want to acknowledge how frustrating and difficult it can be dealing with these court systems. Anyone who has experience knows how corrupt they are. And if you haven't had experience yet, and I say that because a lot of folks think, well, I have a low profile, a humble lifestyle. I'm not going to ever get in trouble. Well, you don't need to get in trouble to go to court. You have to understand, courts are not about justice. They're about business. And when you understand that the governments are bankrupt, they're looking for business. They're looking for customers. They don't care what you've done, if anything. If you have no experience, you just have to imagine the highest level of corruption that you could conjure up in your mind, and then understand that it's about 2 times worse than that. Because there are things going on in the background that nobody sees and very few people know about, where these privateers, which is what they are, they're making huge money in the background in ways we don't even see. All right, and we'll be getting into that in time. But tonight we're going to focus on how we bring the common law into the courtroom and take control, or at least attempt to. And in the process, we really put the actors in a pickle. All right, you can expect the court to ignore you and steamroll you. All right, you can expect that. But with that in mind, what we want to do is set the record. We set the record is irrefutable, it's immutable, and when the time comes, and there will be a time, that record will be recognized and all actors will be held accountable at one point in time or another. Okay, so you can't go into a situation thinking, oh, that didn't work. Well, what was your objective? You expect them just to say, oh, wait a minute, Jimmy, I'll have the clerk go in her office and type you up a nice certificate and say, you win, we lose, we'll just pay you a bunch of money. You think that's going to happen? Of course not. They're going to fight tooth and nail. They're not going to roll over. So you've got to have a backbone, and you've got to stand up against all the onslaughts, as we discussed last week. Failure of due process. But we set the record, and that's what we're doing. That's what we're talking about tonight. Now, let me say one more thing before we really dive into it, and that is that in our experience, a lot of people, if not most people, are looking for that magic document. They're looking for those few little bullet points or case citations that they can use that'll just trigger the court to put their tail between their legs and go scurry into the corner. All right, well, forget about that line of thinking. Okay, there's no document that's going to help you. You have to have a a solid, well-rounded education and knowledge at a level where you can stand up against the onslaught against your rights. When they attack you and ignore you, you need to be able to know your rights and know process and procedure and know the law well enough so that you can maintain and prosecute your own case to its fullest extent. And there's nobody going to do that other than you. Okay? You cannot pass this off to an attorney. An attorney is sworn to serve the court, as you well know. And that what that means is that your rights, your constitutional rights, go right under the bus with an attorney because he is an officer of the court. He's not there to serve you unless it's convenient and he can do it while at the same time serving the court, which means, you know, if there's criminal charges, they'll get you to plea bargain. In other words, get you to plead guilty and get something out of you. All right. And a plea bargain usually means they save money because they don't have to go through a whole court process. They get you guilty. They get the bond set up. They get the fees, the penalties, everything else. The attorney gets paid. Everybody's happy on that side. And you're going to feel good because you got a better deal than you might have thought you would have had otherwise. All right. So only you can prosecute your case or defend your case. And so that's what we're here for, is to help share knowledge and information to help you do that. All right, but don't think you're going to take a document or some bullet points and be successful with that. Okay? You either need professional help, and I'm not talking about attorneys, people that really know what they're doing, to work with you, coach you, guide you, bring you the research, bring you the coaching that's necessary, or get to the point where you can do it yourself. Okay, so I just want you to understand that as a very powerful disclaimer. So this information being shared tonight is for educational purposes. We operate, we gather under our rights of free speech protected by the First Amendment, and we can talk about anything we like. Okay, so let's get on with it. What we're going to start with, if you've been, I sent out in the email, which you likely have seen because you're here and you got the link, a little bit of a summary of the history of what's going on with the Interchange Bistro. So you have an idea what's going on if you read that. Okay, so in a nutshell, after receiving 9 criminal complaints and all kinds of other assaults and fines and threats and license suspensions and all kinds of denial of due process and everything else, all right, Lisa, the defendant, turned around with the help of NATF and started filing counter complaints. And those counter complaints went in at the first instance not under statutory law, but in common law. And this exhibit was attached with those counter complaints. Okay, this exhibit establishes that the counter complainant, Lisa, was establishing her own court, and this exhibit establishes the laws and the rules for her court, because any plaintiff has the option to bring an action at law or in equity or in admiralty or maritime, whichever may apply. And so her counter complaints were coming in as an action at law, and thus the Hanson Court was established. So just to breeze through this very quickly, we start with definitions. Okay, these are the definitions that we're going to be using in our terminology, all right, that we'll use in our documentation. case cites, common law presumptions, declarations of law. I'm just giving you the sections. We're not going to read through it all. You know, what is recognized as immunity or not recognized, as the case might be. You know, here's official immunity. An officer or employee has no immunity for conduct that is malicious, willful, and intentional, contrary to law. So there's a number of definitions there, citations from other cases. This is common law, so we're using case precedents in this matter. The supremacy of common law. All right, so we established that very clearly. Judge, pay attention. Versus legislative edicts. And it goes on. So we're only on page 12 of 33. So you get the idea. It's a very extensive legal memorandum establishing what the rules of this court are going to be. And so this is laid out clearly very, very early on. Okay. So let me bring on Michael, who is our legal team chief. If you have any comments you want to add to that, Michael, and then we'll get into another document here that we want to share that is particularly notable and educational from that standpoint. So, Michael, establishing the rules of the common law court. Just give us an overview of how that works, if you would.
So basically, in all of Lisa's or the Patriot Princess's counterclaims and individual standalone claims, she declared that these were actions at law, and in her inducement, she declared that she was one of the people, and in the court of record. So by the very inducement, she is setting her court into motion, and as she goes into the elements or allegations of the declaration to support her action at law, the very first thing is that the law decreed for the case is incorporated herein. So, attorneys will not pay attention. So they'll move forward without any kind of objection or taking any exception to her court until it's too late. And when her court starts acting, they are trying to figure out, well, we need to find some authority that she can't do that. And there isn't any, because by reason of the law that's set forth in the law decreed for the case, she has the right to hold her court, and she has the right to move her claims according to the course of the common law and the law decreed for the case, as one of the people exercising a sovereign capacity in her direct sense, and using the judicial power of the state to move her claims in a public forum to establish that it is just and fair and according to the law. And that's all that a court is, all. And unless you start weaving in the corruption where you get no justice at all, and then there's commercial things going on. So anyway, so that's the foundation, and in combination with several other pieces of foundation, depending on whether it's criminal or civil. We have some on their claims moving against the princess. We've put in various things like challenges to jurisdiction. If it was criminal, we had bill of particulars. In the civil, we also put in a real party in interest. We asserted by fact of law that the plaintiff wasn't the real party of interest, and we gave him 21 days to show that he or she or it or whatever it was. And
why they're not the party in interest?
Pardon me?
Explain that, why they're not the party in interest with the.
Well, So through the research, we clearly differentiated that the titles that are being used are not or do not comport with the Constitution for Minnesota. So in every reference to the de jure government, it's the little s state of Minnesota. And even in the statutes, it's the same reference. But yet these guys come out with the big S state of Minnesota and don't allege that they are the government. They don't allege anything of what their capacity is. So we challenged it on the basis of what's been written in the Constitution. And, if they're not the real party in interest and they can't demonstrate the legal capacity in which they bring the action, well, there's no action.
They have no standing.
Yeah, the case has to be dismissed. So that's been completely ignored. So there's so many things on the claims moving against the princess that are in the record. And like Mark said initially, it's about the record. If it isn't in the record, it doesn't exist. And if you haven't made the record, shame on you. And if you didn't know how to make the record, shame on you. You're just setting yourself up for failure. So as we're moving along here, the attitude is it's the princess's court, and she has to have the same sense of fair play, because this is a stage. This is a public stage, and everything that she writes has to be reasonable. It has to look good on paper. It has to look good from the common sense. I mean, it can't, and it has to look good from the law and the statutes if they're applicable. So all those things go into consideration whenever the princess writes something into the record. And it's very carefully laid out. The facts are laid out, and the record is always referenced. And then, of course, there's strategery involved in here because they want to play by the civil rules, and they haven't comprehended what the common law is all about, because they've never been taught it in lawyer school. They're taught procedures in the civil rules. They don't even know the difference between what a procedure at law is and what rules in equity are. And predominantly, the civil rules are rules in equity, especially when the judge gets to decide what's fair and reasonable. Hey, does the party get to extend the time in which they have to serve a responsive pleading? I think yes. Well, that's a rule in equity. That never existed in an action at law. If you didn't do it, you're done. It was done. No more. You had no ability to go back and say, oh, geez, please, judge, I was just a stupid one. And I didn't, all right, whatever the reason was, if there wasn't a reason in law to abate, the consequences of the timing, well, you lost. That's it. And that's predominantly why they moved away from the common law, because it was so rigorous. There was no monkey business in the common law, and the remedy in common law was also somewhat limited. So that's why the equity courts came into play, because there still had to be justice if the remedy couldn't be afforded in the common law. And then you get into this mixed court system, and the judges don't even know what the hell they're doing anymore. So anyway, that's some background. So at all times during the case, the princess has thoughtfully and mindfully considered her course in the common law. And so several things came up. So the attorneys playing the game of the civil rules and using them wrongly to try to extend the time in which to serve a responsive pleading, which doesn't exist in the civil rules, nor does it exist in the common law procedures. And unless the plaintiff amended the complaint, or in equity, they applied for an extension of time before the expiration of it. Okay, so the opposing party didn't do either of those. They just assumed that they could take a motion to dismiss, which is allowed both in common law and civil law, and apply it or assert it before the time in which to serve a responsive completing or responsive pleading. If they do that, then they're saved. But what they did is they wanted to make it a final motion, not just a test of the legal sufficiency. They wanted a ruling in the nature of a summary judgment on their motion to dismiss. So according to Minnesota civil rules, that requires a little bit more labor. And that requires full briefing by the parties. And it also requires a minimum amount of time of 28 days in which to do it before you have a hearing. So instead of filing all of the requirements that they had to do for a dispositive motion to dismiss within the 21 days after service of summons, they filed a notice of motion and saying, well, we're not going to file it until after 28 days, according to the general rules for this dispositive motion. So what they did is instead of filing all of the required affidavits and memorandum of law and statement of facts before the 21 days, they said, oh, we're going to schedule a date way out in the future and then work 28 days backwards. Well, that date that they worked backwards put them outside of the response and pleading time. And when they did that, and when they first filed their notice of motion and motion to dismiss without any of the content, more or less just a placeholder without anything behind it, the Hanson Court made an order, said, you have a right to do your motion dismiss in the office of a demurrer to the declaration, but you must do so before the time expires to serve it, according to the due notice given in the summons. Well, arrogant bastards as they are, they ignored it. That was due warning, really, for them, that they erred in the law, in the rules of procedure. So they went along their merry way, and then, of course, the date came along that was 28 days from the date which they scheduled their hearing, and they filed their the memorandum of law and everything to support their motion, but it was too late. So the Hanson Court entered an order of nihil dicit, which is Latin for he says nothing. And when he says nothing and had the opportunity to do so, judgment was against him in whatever form the demands took in the complaint.
Failure to act is fatal. Yeah.
So the Hanson Court issued entry of judgment nihil dicit, NIHIL DICIT, in 1, 2, 3, at least 4 cases, I think. And now everybody's getting riled up, and the judge starts getting involved because the princess got into a little tiff with the subcontracted e-filing service, who wanted to force her orders that require no fee for filing into a motion that do require a fee for filing. And so, and then that ultimately got to the judge, and then the judge issued a goofy letter indicating his complete and total ignorance of what was going on, and trying to take control of the Hanson Court back. So Mark, maybe if you could let me share my screen, I'll show you the order that came out from all.
Okay. All right.
All this. Now keep in mind, the Hanson Court, when they issue, or when the opposing party filed their motion to dismiss with the stuff that they should have filed before the end of the 21 days, the Hanson Court entered the judgment, and it also entered an order to strike the pleadings because they were a nullity. They were filed after the time in which to serve it. The court could not consider it any longer. So then, I think everybody's starting to get the gist of the amount of damages that are here, and that everything's starting to make sense. So the judge has to insert himself, and the judge inserted himself in a rather childish manner. I'm going to try to show this here.
So this indicates to me one of a couple possibilities just by virtue of their behavior. Either A, they don't know what the heck to do to respond to common law pleadings or procedures, even though it's been clearly laid out in Exhibit 1, or they're so arrogant they think they can get away with anything, and they're so used to doing things the way they normally do it that they're bound to screw up. And that's typically what happens. As soon as anybody shows up in the courtroom that has any clue on how to get them to trip over their own underwear, that's exactly what they do. They don't know the law that well. What they're well versed in is dealing in procedure with the brotherhood attorney who's on the sitting at the other table. Okay, so it's a game of footsie to see what's going to be the quickest way we can get this thing resolved in our favor and get the results we're looking for. So either way, they're kind of screwed, and it's kind of funny to watch.
So, Mark, are you able to share the screen, or do you have?
No, you go ahead. You're set.
So what do I do?
Click share screen on the bottom.
Oh, well, let's see if this is the right one. All right, so this, everybody can see this, hopefully. This is the order that came out, and it was duplicated by 2 judges word for word in all the cases where the Patriot Princess had issued orders. So look, we've got the interchange against all these people, loving it, just loving it. And so counterclaim plaintiff Melissa Lynn Hanson has presented to the Freeborn County Court Administration for filing in this matter documents signed by Hanson and styled as, quote, orders, as, quote, entries of judgment of the, quote, the Hanson Court. But what these documents are intended to be and their purpose is difficult to discern with certainty, but they are not orders or judgments of the District Court of Freeborn County, Minnesota. These documents, yeah, well, and you'll see just what I'm making some emphasis on these points here, because we're going to bring them out on the other document in common law.
All right.
So these documents are worded as if Hanson Court were the court, and these items, decisions, orders, and judgment she has granted herself as a litigant. If these documents are construed as anything other than nonsense, they may be read as motions for the type of relief they purport to grant. Entry of default judgments on Hanson's counterclaims, striking responsive pleadings. So he wants to convert these orders into motions so that he can say no to them.
So he can rule on them.
Yeah. So basically this he just keeps going and going, but then he further adds that he's going to hide the documents from the public because he wants to protect them from this nonsense and frivolity. And you know, somebody that, unbeknownst to us, had put him in power to be the censor. So that's what's
court.
So that's what's going on in this court. And so the next thing, so we see all these coming in, and we kind of anticipated that they would happen. So I'm going to see if I can't. How do I do the next one here?
Stop sharing and start again.
Okay. So so after this court and the judge of the other court filed all these into the record, you know, we have to do our due diligence and put our opportunity to be heard. And really, it's the court that's going to be heard. Let me pull this up here. So basically, when a court has overruled, or not overruled, but has not there was a fact that was considered in the decision, or you know, some material was passed over that was essential to making a decision. In other words, if there was some kind of error of fact in the record, it has to be corrected in the court that issued the order or the judgment, because when you go to the appeal, all deference is to the trial court on fact. So you must proceed in the court where the error of fact or the passing over of fact happened to get it corrected. And the court could do that on its own motion, and any one of the plaintiffs could petition for it. So given that this is the Patriot Princess's court, we went to on our own motion to issue the writ of Coram Nobis. And I got
I've got it up. Want me to pull it up?
Oh, yeah. Okay, go ahead, Mark. I'm having trouble with I've never done this before. Okay. So you go ahead and pull that up, and then we'll just walk through it. And it's very well laid out in terms of, remember this is a public forum, and every document in here has to make sense. And somebody who reads it would have to say, yeah, that makes sense. And the only rub in here is that who issued it, and that's a pride issue. I don't think you'll find anything that the judge is the only one that can then hold the court, and he won't find that authority.
Right.
So what we have here, in our notation, our notation is completely different than their records. We're saying in the little S state of Minnesota District Court, because there's only one reference district court in the Constitution. Although it may sit in any county, it's still a singular district court if it's constitutional. So the next one is let's go down. So we have a writ of Coram Nobis, and then orders to restore the court.
Restore the defendants. We've got the governor, we've got Ellison, the attorney general. We've got a bunch of people in the attorney general's office. We've got state investigators, health department, and so on. Long list. Okay. Comes now in court.
So now we're saying who is this? Who's coming with this paperwork? It's the Hanson Court, and we define the Hanson Court. So look at the footnote, Mark. Number 1 is at the bottom. Law decreed for the case. Number 15, and if you could pull back up 15, we'll just go to that, so they can reference. So not only can the audience reference it, but this is what the law decreed for the case is a separate document, Mark. It was filed with the Exhibit 1. So if you could pull that document back up and show paragraph 15 of the law decreed for case. See, now we're pulling all the stuff together. We're pulling all the stuff that was initially declared for the case without objection.
Yeah, I can't bounce back and forth so easy. I have to stop sharing, open it up.
Yeah, okay. Well, anyway, if the law decreed for the case on paragraph 15 established what the Hanson Court was. And so it's that declaration is referenced back to the initial counterclaim or claim that included the law decreed for the case. So go back up to the top.
Yeah. So to help you out, Judge, this is what we're talking about.
Yeah. So everything is documented, and it's all references to the record that has been previously laid out. And so we're going down. Let's go down, Mark.
Tell us what Coram Nobis is.
Coram Nobis is the matter before us. It means that the matter is still before us, and it's still within our jurisdiction to change or add or modify it if there's cause to do so. In other words, it hasn't left the court for appellate jurisdiction. And this fact type issue is the only one that needs to be addressed in the trial court. So it can be done in this way, and typically it could also be done in a motion for a new trial. You know, if facts were overlooked at the end of the day, if facts were overlooked or new facts came into play, or factual material was overlooked in the judgment. So we establish some facts that you know, Hanson set forth the summons and complaint with the law decreed for the case in number 1. So we're basically telling the story of the record right now. In the induction of the declaration, it set forth the manner in which the action of the law would proceed in the determination of liability for each of the named counterclaim defendants to the money damages demanded therein. Oh, we're just telling the story that's in the record. Number 3, no objection or exception made by any counterclaim defendants or agent of the district court, 3rd Judicial District, to the manner in which the civil dispute would proceed to resolution. Well, that's important.
Nobody objected.
Nobody objected. So we're going forward. And so the foundation is just laid, and now we're building a house. So also, this is an important fact. Hanson was forced to give due consideration upon her declaration to move her counterclaims against the named defendants. You know, they demanded a filing fee. Well, you know, when we have situations like that, don't we call them contracts? That becomes important later. The law decreed for the case set forth the particulars of the common law upon which the action would proceed. So we're telling the story. Each counterclaim defendant was served with the declaration. Each counterclaim, no counterclaim defendant served and filed a responsive pleading before the expiration of time to do so. The court and the Hanson Court entered judgment nihil dicit on April 5th against each one according to the demands, as duly noticed in the summons. As provisioned at law, according to the course of the common law. The court administrator, in concert with certain employees of Tyler Technologies, a foreign private sector corporation registered in the state of Minnesota, delayed and ultimately obstructed the ministerial duty to enter documents in the court record. There's no person in the occupation of the constitutional office of clerk of district court. They call him an administrator, but you know, the legislature is not free to rename offices that are in the Constitution. Number 11.
Explain who is Tyler Technologies.
Tyler Technologies is the business that is behind all of the electronic filing that seems to be within every state. And their employees number in the 5,000 range. And somehow, you know, they're in every one of these states as an electronic filing system. So we're now making a declaration that the legislature delegated no authority to the Tyler Technologies to make legal determination in respect of any document filed, which is what they were doing. They were determining that Lisa's motions were not orders, they were motions, and they needed a filing fee, and they weren't going to file them until Lisa capitulated to it. And it also, legislature delegated no authority to the court administrator for legal determination of any document. So we're just laying out the facts, we're telling the story. And then we're saying, well, the court administrator, in concert with the administrator of these proceedings, Joseph Chase, who's the judge, and by a purported order, conditioned the filing of the orders of the Hanson Court upon entry of the orders under the category of motion, and further conditioned upon payment of associated filing fees as a motion. So Chase now is getting involved, and he says, you know what? These order documents will be filed as a motion, and she will pay for them, or they're not going to be filed.
So they're denying access.
So he filed that on April 8th without a filing fee. Interesting.
They're denying access to your own case. You can't even file something in your own case.
So then the judge further specified that all the orders of the Hanson Court are going to be hidden from the public. So now we get it. So after laying the story of the record, now we say, why are we doing this? Why does the Hanson Court have to get involved in this matter? So the purpose of the writ is to restore the orderly decorum of the court, to correct defective impromptu legal process, to correct manifest errors of fact and the usurpation of law of the case, and to rescind judicial acts of the magistrate proceeding without a cause in equity and without leave of the Hanson Court. So that's the reason why we're making the writ. The guy's doing whatever he wants to do, and it's not his court. So now we're given some background, some rationale. We're the Hanson Court is considering this little message from the Sixth Circuit, that a central tenet of the Republic is a characteristic that separates us from totalitarian regimes throughout the world, is that the government and the private citizens resolve disputes on an equal playing field in the courts. When the citizens face the government in federal or state courts, the job of the judge is to apply the law, not bolster the government's case. The Hanson Court is mindful of the wisdom of Thomas Jefferson when he commented, "We all know that a permanent," and I put in their brackets, and properly, even those judges whose terms of office are limited, but who otherwise have private alliances working against the people and causes against wrongdoings of agents of the government. So Thomas Jefferson was really talking about federal judges who have a lifetime tenure, on terms of good behavior, and which judges acquire a spirit decor, that being known, they are liable to be tempted by bribery, that they are misled by favor, by relationship, by a spirit of party, by devotion to the executive or the legislature. I mean, Thomas Jefferson laid it out exactly what's happening today. These judges are corrupt, and we don't know why they're corrupt, because if they were to disclose that, then they would label themselves as corrupt. But we know it. We know them by the fruits that they produce. So now this is the reason that Hanson instanced her court as a court of record by express declaration in her claims. And so we're bringing the magic of the common law all together here in this writ. It's an educational opportunity for the judges, for the public, and brings forward that which has been hidden by the bar attorneys, and that is the common law. So now we're talking about the structure of how this writ's going to be laid out. So it's going to be laid out in three parts: judicial cognizance, findings of fact, discussion, and conclusions of law, and then finally the impeachment and the writ. So we start with judicial cognizance under 1. And so the court now takes cognizance of the law decreed for the case. So we're going back here and we're defining what these things are. We're basically bringing forward from the law decreed from the case those definitions that were decreed therein, and we're reasserting them here. So go down, Mark. Remember, we saw the common law, and this is the definition of common law. Go down. The court. We're telling them again what the court is. Keep going, Mark. So you saw these, briefly going down through the record. Now we're defining what a court of record is. That was also in the law decreed for the case. So it has 5 functions, and one of the most important ones is a judicial. It's a judicial tribunal having attributes and exercising functions independently. Underscore, highlight, quotes, and double font this one: independently of the person of the magistrate designated generally to hold it. That's a whole lot of magic right there. The second whole lot of magic is that they proceed, of course, to the common law. Well, the common law is not the civil law that the legislature is defined. And then what is frequently relied on as the only element of a court of record by its expression is that the judicial proceedings are enrolled or recorded for perpetual memory and testimony. That is the only thing that anybody ever relates to a court of record, because, well, that's what it says. That's a court of record. Well, okay, the records are there, but there's the other elements are so critical to this. and they've been buried. And that's what we need to restore, because it's only at that restoration that we can bring back our court and get around and defy the commercial courts that are existing right now. And the fifth is not a requirement, but it's generally there. It has a seal. And it's always been that in a court of record, that's where a person's, people's rights were determined. It could only be in a court of record. So now we go into some other definitions: republican government, sovereignty, and these are just bringing forward the laws decreed for the case. Now back up, not back up. Duty of the court. So now we're starting to say we've got to. We're saying what is the duty of the court? I mean, really, why did the people put a third branch of government in there? Well, here it is. Because it was a duty of the court in a case properly before it to maintain unimpaired those securities for the personal rights of the individual, which have received for ages, that's common law, and the sanction of the jurists, that's all the judges who ruled on the common law, and the statesmen who were at one time writing laws to protect the people. So this is probably one of the very key quotations from a Supreme Court case that really establishes the purpose of the court itself, and how the reason, according to the law decreed for the case, how Lisa can move her claim in that fashion, and it makes sense all the way around. The only thing that gives them the rub is that their appointed judges are now not in control, which they find problematic, because now they don't get bribes anymore. So now here's, I referenced what a writ of Coram Nobis was. Now I'm pulling in Supreme Court case information that defines what the Supreme Court has researched that the writ of Coram Nobis was. And they researched it back into the common law of England, the common law of the states, and this is where they came up with, and they said it's valid. It's still valid to be issued. So we go back to, now we bringing up sovereignty of the people again. We're telling who's really in control. Well, it's the people. It's either the people in their indirect capacity through their representatives, or in their direct capacity, however they choose to initiate that direct capacity. But as long as it's according to the course of the common law, then they have the right to do it. So that's all laid out. Gives some deep explanations about the hierarchy. The true hierarchy is God, man, government. And that's what the Supreme Court case here references. So that's why that's pulled in here. We go down a little farther. We're still talking about how the sovereignty of the people got to be, and what restraints, if any, are there on sovereignty. And one of the important one is the sovereignty itself is not subject to the law. And when they're saying subject to the law, they're saying subject to the law of parliament or the law of legislature. The king and each of us in our sovereign capacity are subject to the common law, and that common law is derived from God's laws and the 10 Commandments, right, which are founded in the 10 Commandments. And we all know that those things are right and wrong. So the common law is often referred to as a negative force. In other words, we can do anything that we want to do as long as we don't hurt somebody else in doing that. And that's the true freedom that this country had, and still could have, if the people realized that they have that access, and they could throw the bar attorneys out of the legislatures and start making some changes for our government that need to be made. So now we're referencing the sovereign and as a king, which which at one time, that was the sovereign. The people looked at him as the sovereign, as the next in line to God. But when we had the revolution, well, all that sovereignty devolved on the people. So, these Supreme Court cases say that, we basically now have the prerogatives that the king had. So now we're exercising those prerogatives by exercising a court in our name. And that's what Hanson has done. So remember, we're doing this all by reason of law. It's not an opinion. And it could, a sovereign could have an opinion, but his opinion may not carry his or her opinion may not carry weight in the public eye and may be chastised for it. But if the opinion is based on, quote, the common law that is accepted as true in common usage, well, that just stands in and of itself. It's not an opinion. It's what's been accepted, which is the whole definition of common law. So we go through a whole bunch of discussions using Supreme Court cases and things like that, talking about the king, the relationship of the sovereign, just to put perspective as to whom Lisa is in this action. So now we're talking about the facts, the case. So basically these orders were going into the case, and there was a dispute between Tyler Hosting Technologies and the court administrator, and Lisa made some demands. You better do this. You better perform your ministerial duty, or you're going to be in trouble. And so the court administrator must have gone behind the scenes and got the judge involved. Now, the judge is not an administrator. There was no judicial issue, in just a traditional court sense. There was no judicial matter for him to rule on, presented by any party, let alone join between the parties for a resolution. So this is completely not a judicial act. So, and we're just explaining this. We're explaining that in an enumerated fashion, and then we're bringing in that the court is a commercial court. We're making some accusations now. We're saying that the court that he's coming from is not the court that we're in, or we've declared. So there's some incongruency between the two courts, and now we're showing some of the differences and supporting it by fact. So we're basically leaving it with the impression that because of these facts, that this court is an inferior court to a district court of record that's instituted under the precepts of the Minnesota Constitution. So now we're saying that even in her in all of her paperwork, she's even stating in the paperwork that it's a different form than what everybody's used to seeing. And the whys of doing that now is to going right back to the Constitution. And the reason that she references her court to the Hanson Court is to clearly delineate and differentiate that this is distinctly different from the normal operations that everybody here in this business of the court is used to seeing. And she's further saying that the Hanson Court didn't render any judicial determination on any joint issue of fact, which is a function of a judicial tribunal, which would be the jury. Next. And so every order that the Hanson Court issued was based on the facts and application of law of the record. And there was no matter to be put before a jury for a trial. So now we're saying the judge is not the court, which he seems to think he is. Now Judge Chase, and so does the other judge, states that the Hanson orders are not of the District Court of Freeborn County, Minnesota. And then we say, well, neither is his, because It was filed in the state of Minnesota, Court of State of Minnesota, as the district court, third judicial district. And that's not an order of the district court of Freeborn County, Minnesota, just like he said before that the Hanson Court wasn't. So we have two orders that aren't from the district court of Freeborn County. So whoop-de frickin' do. So now we highlight the admission that he admits the lack of comprehension as to the intent and purpose of the orders of the Hanson Court. Well, that's kind of odd coming from somebody that's been on the bench probably for a long time. Then we say, well, contrary to the admission of lack of the comprehension, Chase then admits proper understanding of the intent and purpose. But he wants to make it, he wants to make him his emotion so that he can rule on him versus orders so that he can't. Go down. So now we nail him. In the apparent cognitive dissonance. That's a fun word, a fun phrase. Look that one up. In order to construe as anything other than nonsense in his sense of charitable reading of the documents as one in nature of emotion for his own disposition under procedural rules and equity foreign to the proceedings and according to the course of common law. So we're saying that he wants to do something that's, you know, that you can't do in a court of record in an action at law. So then we're saying, well, without his authority, he directed the court administrator to reject the filings of the orders. And so we're just chastising the bejesus out of him. And these are a matter of fact. We talk about, you know, forcing them into motion so that she has to pay for them, and then you know, then him, you know, ordering the clerk of court or the district or the court administrator to hide the documents with you know, a lot of insinuation that they're illegitimate. You know, so he's justifying it, but only on his own sense of reality. Okay, next. Now we're talking about some of the orders themselves, as he's alluded to in his order. That he says, you know, a judgment of default effectively is harassing, and he relates it to other things. So he's trying to do some ad hominem attack here, and he's, you know, asserting his right to censorship basically to the public, because we don't want the public to think that these are real.
So this document is essentially calling him out for his wild, erratic, and unfounded accusations and attempts.
Exactly.
Yeah.
On reason of law.
Right.
And it's all a matter of the record, Your Honor. I have nothing further to
on
add.
The record.
So now after we lay out the story of the case with respect to the judge that's involved, now we have the discussion. And the discussion says that you know, Chase had no authority. He was in a ministerial role of an administrator in a court of record, proceeding the course of the common law and an action of law. And he stepped out of that function as an administrator to assume the judicial tribunal while sitting as a magistrate. You just can't do that in a court of record in an action at law. The judge or the magistrate there purely moves the case along according to the rules of the common law.
That's a violation of oath and a war against the Constitution.
Well, it's, and you know, just an ignorance. I mean, these guys don't even know. Now we're talking about the genius of a court of record, and why it was important, and how every one of us, as one of the people and a joint tenet of sovereignty, has this right. And if we want to do it and we know how to do it, there's nobody in these United States that should be able to stop it without consequence. And like Mark said, because the whole purpose and intent of establishing this government with the Constitution that we did was to avoid the bullshit that we see now. Sorry, excuse my language.
No.
So we're telling all of his failures on the story that we just told against the proceedings according to the course of the common law. So again, we're referencing the failures or the dereliction of duty based on the story we just told. And we're saying now we're going in. It is a design of our systems of jurisprudence that courts have no jurisdiction until the party comes forth and declares a cause needing resolution. Well, think about that. If nobody had a cause needing resolution, there would be no court. Right?
Exactly.
Yeah. So now when somebody comes forth and declares a cause needing resolution, the jurisdiction that's exercised depends on how the cause is declared by the plaintiff or the counter plaintiff or the third party plaintiff. Remember, operative word is plaintiff. You cannot exercise these principles unless you are the plaintiff. Now we're defining jurisdictions. It could be administrative, could be at law, could be at equity. The jurisdiction declared at law in the court of record and under the sovereignty of one of the people acting in her direct capacity. That's what we're saying that the declaration accomplished for Lisa. So we're summing it all up. We told the story. We told what a court of record is, what the common law was, and now we summed it up in that last sentence up in paragraph 63. That in the declaration, that the jurisdiction declared at law in a court of record and under the sovereign authority of one of the people acting in her direct capacity. So that just now makes the inducement a 2x4 whack across the head that you just completely misread or overlooked. Because now we tied it all together with the law decreed of the case and law decreed for the case. And we're basically now creating cliff notes for the attorney who didn't pay attention to what was being presented to them in the first place. So now we're getting into the meat.
As if that wasn't meaty enough.
No, as if it wasn't meaty enough. Now
now it's getting good.
We're gonna explain it to him a little bit different, like Judge Neapolitano says. In other words, to state it differently.
Yeah.
So it's essential to understand what are a sovereign, a magistrate, a court, and a court of record. So we're re-emphasizing those very definitions that we laid out in the beginning. The court is the person in suit of the sovereign. Who is the sovereign? It is the people acting indirectly through their representatives or directly in their sui juris capacity as one of the people. So we're giving rationale to why the Hanson Court can exist and why it has authority. General sovereignty reserved to the people without diminishment. It's by the prerogative of the sovereign whether and how a court is authorized to proceed. In this case, the chosen form of the court is a court of record. Now we're re-emphasizing the very definition of a court of record. Again, magistrate is a person appointed or elected to perform a ministerial service in a court of record. His service is ministerial because the judicial functions in a court of record are reserved to the tribunal. And by definition of a court of record, a tribunal must be independent of, so stated differently, Your Honor, The tribunal must be independent of the magistrate. The non-judicial functions are ministerial because they're absolute, certain, and imperative, involving merely execution of specific duties arising from fixed and designated facts and application of procedure rules according to the courts of common law in an action at law. People. So we tell them the story, we whack them upside the head with a 2x4, and now we're tattooing it on their eyelids. The magistrate holds only ministerial authority. He holds no tribunal authority and cannot in any way substitute himself as the total equivalent of the court to thus exempt himself from the court's jurisdiction. Now, remember when we talked about the force to pay something? Now we're bringing in contract law. Even in appreciation for the district court, as a commercial court, Chase acted without the terms so specified in the presentment under obligation of contract, whereby Melissa Lynn Hanson gave due consideration and whereby an authorized agent of the commercial court accepted said consideration for providing the service according to the terms of the presentment in the resolution of her claim. So there's two whack attacks. We got them on the common law side, we got them on the commercial side. So the record, now we're saying, okay, we're bringing some finality to it. The record shows that the rules of court of record were not followed. The magistrate usurped its function and substituted himself as a tribunal. The court was ineffective in furthering the disposition of this case according to the provisions of the common law in an action at law. These failures are sufficiently disruptive to the goal of providing, with equal footing and in accordance with the principles and usage of the common law, the disposition of this case is a matter of common law, that the court finds it necessary to issue a writ of error coram nobis as follows. Now, therefore, the Hanson Court issues a writ of coram nobis, to wit, order to the correction of record. The Hanson Court impeaches and rescinds the order entered by Joseph F. Chase, dated April 8, 2021, in its entirety. Wow, that just wiped out his little regime. Now, in order to restore the dignity of the court, we're ordering that the court administrator change the orders entered by the Hanson Court from the status of motion to order, and to refund to Melissa Lynn Hanson the filing fees thereto within 5 business days of the date of this order, or shall cause why the court administrator should not be held in contempt of in the amount of $500 for every day beyond the 5 days that she is in civil disobedience. Now we're getting the next order is ordered that Chase must stop the usurpation of his ministerial functions and the administrative of these proceedings as officer of the court and the magistrate therein or herein. Further, under obligation of contract in the commercial court, and must stop substituting himself as a tribunal in this court of record that is independent of the magistrate designated to hold it. Again, we're bringing it back to the definition. Further acts of disobedient will be held in civil contempt of court in the amount of $5,000 per incident. And that's the writ of coram nobis, and it went in 6 cases.
Affecting many defendants. Wow. Wow, that's quite a lesson right there.
The education in here, if one of the enemy elects to try to understand it, is hugely powerful, because it says that what they've been doing is wrong forever.
And they need to reevaluate the direction of their life.
Well, these, I think there's corruption involved. There's intentional hiding of the common law to monopolize the law industry by the private membership of the bar attorneys. I mean, you can see it. It's just fair. All the laws are written in favor of that bar association. It's just on its face, it's evident. And people who aren't in the know get the sense of wrongness, but because they don't know how things, just sit there and wonder it's wrong. They put unhappy face emojis on Facebook. And that's the extent of their revolution. So what I'm saying here, people, is that the NATF is an organization, a grassroots organization centered on the education elements and the help elements to get the people back in their rightful position over the government that serves them. And that first requires an understanding. It first requires that an exposure to the tools that do exist, but aren't there because the Bar Association has suppressed them, and everybody thinks that their only remedy is in the statutes, and that's completely wrong. Completely wrong, backwards, and that's what got us upside down. And until people, I've worked, with the Hansons. So the Hansons have done one fantastic and phenomenal job, because they knew it was wrong. They're trying to find help to get it. And now that they're being, mentored and educated, they're starting to take on the law for themselves. They're reading it for themselves. And I just remember the other day, I missed something. I missed something in the federal statute that had more weight than what I had put in there. And it was all because they chose to break apart the law, and where they did not understand, they questioned it. And that's the very beginning of learning. And that's how I started, and that's how every one of you will start in your endeavors. And you will get smacked upside the head. You will have some failures, but there will all be very positive experiences for the wherewithal that you'll gain as you move forward to rise to the position that you rightfully belong in.
Yeah, so the record is set mightily, I might add. And, again, as I mentioned in the beginning, we do not expect these people to roll over. They don't understand this very well, if at all, or if they do, they will fight tooth and nail to continue to sweep it under the rug. Hide it, move it, destroy it, keep it out of the public eye, because as the public becomes aware, as the people become aware of the power and the rights that they have and start exerting those rights, these guys are done for. Their business is bankrupt. All right, so you see the confrontation that we have here. We have a clash of the titans to take down the most corrupt industry on the face of this planet. This is not about a single case or a single incident or business. Okay, the issues that are being revealed here are earth-shattering. The fact that the capital S state of Minnesota is a corporate imposter imposing itself over the constitutional small s state is no small matter. And all of the things that Michael has covered, absolutely groundbreaking. And so we need the entire country to get behind this effort, okay? We're in the process, we've already engaged a very well-connected, highly professional, highly esteemed PR firm to start bringing this to the attention of the nation, getting this well-placed. He's already talking about getting this case positioned with Fox News and a whole long list of other high-profile media, all right? That's gonna take some money. All right, so Lisa needs help on this. We've already started discussions as of today. A very direct letter, plea for help, went into the military brass for the US Army in the Pentagon. We're trying to open discussions with the Pentagon officials to see what role the military can play in the face of this tyranny. And in the letter, it was very clear that we have enemies who have infiltrated all of the seats of power within our country, and they must be rooted out. And if the civil servants will not honor their oath of office, and there's no recourse, there's no redress, there's no remedy available to the people in the civil court system, then it comes down to the military. And so we've initiated attempts to establish communication there and open up some discussions. And the solution is very simple. It's very simple. So last week we talked about filing criminal complaints in the federal court system to have criminal agents in government arrested. All right, and it seems they're very reluctant to do that. So if that's the case, who do we turn to? Well, we turn to the military. We turn to the court of public opinion. And that's why this PR effort is coming forward. This video is not going to be put behind a paywall. This video is going to be public and made available, and we want you to share it far and wide with anyone who you can think of that would have an interest in saving the country. Okay? And I just put a link in the chat where people can contribute financially. Michael, we've got the order of judgment going to be filed soon. You want to just give us a quick recap of what that involves?
Well, there's actually two. Okay, one happened and we discussed it. It was the entry of judgment nihil dicit, which means they failed to appear, and so whatever the demands were in the complaint would be entered as the judgment, because it's assumed in that case that there's no dispute. Again, he who's silent acquiesces. It goes back to that very principle again. So there's, I think, 3 of them that are like that, if I'm not mistaken, 3 at least. But then there's others where the party did file a motion to dismiss, and it was timely and it had substance to it. So the Hanson Court would look at that and treat that as a demurrer to the complaint, again according to the law decreed for the case. And basically there is everybody has had the right in common law and in civil law today to dispose of the case on the front end if it wasn't legally sufficient to go forward in the process. You know, it just doesn't make sense. You know, why go through the effort if there's if the claim wasn't really established there in order to grant the relief that was requested? I mean, even, you know, most people in the civil law proceedings know that. The issue is that in common law, as a demurrer, that served as a means. It was kind of a I don't know the word for it, but I'll explain it. So on the one hand, the defendant could dispose of the case and be done with it without investment of any sort of, you know, effort in the defense. But his consequence is that since he did not go through the effort of answering the charges against him, whether he denied or affirmed that some fact happened, and choosing not to, or not having an affirmative defense even if he did do it, that whole matter is what the common law was based on, is to resolve the claims on issues of fact and issues of law. Now, if the defendant comes forward and says, well, the plaintiff hasn't made a legally sufficient case to support the claim that they have. It might be jurisdiction, might be a failure to state a claim, might be a number of things that would prevent the court from moving forward on the claims. If they did that and it got overruled by the court in common law and in action at law, then the plaintiff got judgment. The judgment was rendered in his favor because the defendant chose a course of action not to answer it, and he relied on the application of some legal principle that said that was insufficient. And so he had a very, very important choice to make when he demurred to the complaint, and that was something of very, very serious consideration. But in today's day and age, because the same principles apply to test the legal sufficiency. That's what they say. That's derived from the common law, to test the legal sufficiency of the complaint, assuming all facts as alleged are true in favor of the non-movement or the plaintiff, and any reasonable inferences of fact therefrom, if the complaint is sufficient to state a claim or to overcome any assertion that it's legally insufficient by the opposing party, then they just move on. In today's day and age, there's no consequences. So guess what? Therefore, everybody does the motion to dismiss as a matter of course in civil proceedings. It's just it's a delay. And if you win, or if you get a corrupt court that'll throw your case out right off the bat, well, now you're left frustrated with no remedy. That's exactly what's happening today.
Yeah.
The attorneys put attorneys against a party who stands moving his claim on his own. Notice I didn't say self-represented. Stands moving his claim on his own. If he's not an attorney and the opposing side is an attorney, and they move a motion to dismiss, the judge just rubber stamps it with no consequence. And if and they don't even give a rationale. I've been through a number of these, and there's no rule of law they apply. It's all just stupidity. And when you're dealing with the brotherhood of judges, you're not going to get an appellate judge to overrule the underling, especially when it wasn't an attorney who did it. They can't support the people who know the law.
Right. So, Michael, what I wanted to get at was that we have pending very shortly that the Hanson Court will, if not has, either has or overrule these demurs, delayed motions, and will shortly enter judgment. And
yes.
What are the damages typically on each of those? Are they pretty much identical?
I think the total of the overruling of demurs and the entry of judgment on the whole explanation that I just laid out as to why that can happen is, I think something on the order of 60 million.
Uh-huh.
And those are all against Martinez, the city attorney.
Just one defendant.
Mm.
Wow. So we had a discussion today that, we're very close to opening discussion with the attorney for Martinez about having a settlement conference.
So there's a little strategery in here, because in the civil rules, they've failed to return discovery on request for certain matters of admission, which, if admitted, would win our case 100%.
Yeah. So
they failed to return it within the 30 days that they had to. So according to the civil rules, those matters requested for admission are deemed admitted as established conclusively. which means that any matter that's set forth in the admission does not need to be proved. And every claim that Hanson has is based on that request for admission. So the whole case is won on that alone. So the strategy here is to say, hey, all of your cases are in default on the admissions alone. It seems to me that you will lose this case on summary judgment on these admissions deemed as conclusively established. So we'll give you 5 days to see if your attorneys want to offer to settle the matter. And that's it.
Yeah.
And then if they don't do it in 5 days, then we waylay them on the overruling their demurrers and entry.
So that's their only opportunity to negotiate the 60 million down to maybe 40 or 50 million, or whatever the negotiation might result in. And the point I wanted to get at is to make sure that everybody knew that we have a litigation finance option for everyone to participate in any awards being given, okay, or collected. So that'll be a process, no doubt. They're not going to roll over on it, but you can see the position that the Hanson Court is in. There's no way for them to wiggle out of this. The record is set, it's clear, the law is laid down, and they've got nowhere to go. All right, so for any contribution to support Lisa in this case financially, donation of $500 or more, that would entitle the contributor to 1 unit pro rata with others that are participating to share in the proceeds of the awards damages. Okay, so this is a financial opportunity, and it's not a pig in a poke. You can see the position that this case is in, and this is only on a few of the cases. There's a number of others that are also pending that are not quite as close. Okay, they have a little further to go, but you can see where this is going when we apply the pressure of the court of public opinion to this, when we expose the shenanigans, the ignorance, the arrogance, the criminality. There's nowhere for these people to go. So they're getting hit on the law in the court. They're getting hit in the court of public opinion, and they're getting it from multiple sides. So, and with God's grace, who knows? We might even get the military involved.
And the other thing is that we just can't understate the expenses that are involved in here. I mean, all the filing fees that Lisa had, that's $75 for every time she files a motion. And until she gets it back, that's a financing that has to be covered, plus the fees for other resources that are involved in helping her to move her case forward. I mean, it's a lot of money. And I'll tell you, fortunately they had the resources, at least on the front end, to carry the burden, but they can't do it. They can't do it. They can't carry this the whole way.
They're getting behind, and help is needed. So look at it as a financial opportunity, not just a giveaway. Okay. So 500 or more. If you can't do that yourself, hey, get a couple friends involved. Say, hey, let's 5 of us put in $100 and let's do this. Let's push this thing forward. Help save.
If they do that for the lottery, certainly you can do it for your freedom.
Yeah, yeah, exactly. Huh? So anyway, watch for this coming up in the news. We're paying a very successful PR consultant. Not an exorbitant fee. He's very reasonable. I'll say that. But he's highly professional, very well connected. He knows his stuff. And so his fees are involved. There's going to be fees to do a certain amount of advertising and getting this out to the public. So, it's all adding up. It's all adding up. So every bit of help we can get. And if you can't do anything financially, help us share the information. This video will be available tomorrow. I'll send a link out. It won't go on YouTube, but it'll go on another platform, and help us share it, get this word out. So that's how you can help. You probably follow influencers on YouTube, podcasters, and people that do their own YouTube channels. They have their own followers. Help get us on. We'll get Lisa on for an interview. They can maybe get an exclusive interview with Lisa and or myself or Michael, and we can do a panel talking about this. I mean, this is earth-shaking, what's being presented here, and I'm sure the reverberations, if we can get it out, will reverberate around the world. So the way we see it, we're being led by the Holy Spirit. This is a biblical movement, and we're on the verge of making history here with the issues that are being raised. So we're on a mission. So let's leave it at that. I think we've gone long enough, well over 90 minutes. So I appreciate everyone's attention. I appreciate your help in helping us get the word out. If you can help financially a little bit, and share in the rewards once we start collecting those awards damages, that'll be fun, for anybody that can do that. So
hey, Mark, we got a hand raised.
Okay.
507 Patriot.
Yeah. Well, I didn't want to entertain questions right now. I want to wrap things up. So I apologize for that. Otherwise, we can go on for hours. That's kind of how it goes. So if you've got comments or questions, please send those to the through the NATF website, national-taskforce.org, and we'll be happy to entertain. If you got ideas or information or connections that can help contribute to this, or just matters in general, we'd love to hear from you. We'd love to talk with you. Okay. But as it goes, these discussions can go on for hours, and I just want to keep this reasonably timed. Okay. So any final thoughts or comments, Michael?
No, I'm good. I think there's an excellent session, and I think the point is that the common law needs to be exposed from its hidden state, and that's what we're trying to do here. And hopefully that you've gotten an inkling of what's behind here, and what you can research for yourself and pull out and understand, and get the posture that you need to have to stand against the agents that are supposed to be serving you.
And let me make one final comment, and that is that we need to be involved in forming our own government under the Republic, under common law. And so everybody should be working with their local state administrator or state coordinator for the American States Assemblies. So go to the American States Assemblies. Let me put the link in here. I believe that's correct. And get involved with the state assembly. They've already formed a marshal service. The marshal service needs a functioning government behind them in each state, according to common law. All right, and I think most of you are aware of the American State Assemblies and what's going on. So we need to come together on it. It's an educational opportunity. Okay. So let me just leave you with that, and thank you for your help, your participation, and what's going on. And look forward to covering some more new ground next week. So come back next week, bring a friend. I'll try to get our room capacity expanded here because we're quite often pushing our limit. So bring a couple friends next week, and hopefully it will be It will be a help to get the word out. So with that, I will say good night. Take care. God bless. And see you next week if we don't talk to you sooner. All right. Good night, everybody.